Chair and Commissioners, you'll recall that 3 weeks ago Mr. Carrim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Carrim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Carrim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Carrim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Carrim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Carrim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Carrim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another. And they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Carrim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Carrim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Carrim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the Commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Carrim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Carrim's appearance or non-appearance to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this Commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Carrim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Carrim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskelson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Jaskelson. Yes, Mr. Premier.
Good afternoon, Chair. Good afternoon, Commissioners. 5 brief points in reply, if I may. Firstly, do you have the Commission's correspondence bundle? I was handed one about 10 minutes ago by a Commission representative, but it's called Carrim Suliman Correspondence and Sundry Documents Witness Bundle. I'm going to refer you to the confidential medical report in that. I'm not going to discuss the contents, but if you can turn up page 128 of that medical report, when you read paragraph 1 of that report, that will deal with my learned friend's contention that there's an inability to explain attendance. And when you read paragraph 2 of that same report, particularly lines 2, 3, and 4 of the second unnumbered paragraph, that is a direct response by a medical practitioner as to why, potentially, there's an inability to give answers. So insofar as my learned friend says there's just no explanation at all, that's contradicted by the medical evidence of an expert in a particular field of medicine, which my learned friend is not. That's point number 1. Point number 2, my learned friend must choose his words very carefully with all due respect, because my learned friend talks about hundreds of millions of rands, companies that are continuing to service the state, multi-million rand businesses and so on, and he uses the quantum of my client's otherwise legal business to evidence some or other gratuitous behavior in front of the Commission. Until such time that a court orders otherwise, that there was unlawful business dealings with the state to the tune of those hundreds of millions of rands, the fact that there's business that may or may not be done to the tune of hundreds of millions of rands is neither here nor there. So my learned friend must choose very carefully his words in elevating otherwise perfectly legal facts to be weaponized into some sort of smear, potentially, against my client and otherwise lawful activity. The third point that I would say, in respect of Mr. Carrim's undertakings to give the evidence, is you'll know that Mr. Carrim, if you'll give me 1 second. I'm indebted to Ms. Madlanga. On the 13th of April, suffered the medical incident, and at least on our version, he has been in medical treatment since then. And so his ability, notwithstanding undertakings whilst given in the box, must be construed having regard in particular to that second paragraph that I referred you to on page 128 of the bundle. Can I say, in number 4, in respect of these whistleblower reports and the alleged corroboration or not corroboration that has occurred or not occurred, and this is a 2-part point, so you'll forgive me. The first part of which is we only learnt about these facts today. I know my learned friend says he also only learned about these facts today, but apparently these social gatherings were known about before. And it's the first time we're learning about these things today. And I must place this on record, in as much as I don't for 1 minute question my learned friend's ability to rely on those allegations to raise a question about Mr. Carrim's position in front of you. We would respectfully submit, and I know earlier there was an exchange about whether respectfully is respectfully or not respectfully, but I'm respectfully submitting.
I'm happy you were listening.
Yes, no, the commission is warmed up by the time I come here, so I know what I'm walking into. The point that I would make is that it's unfortunate we're learning about these in an open proceeding of this kind, and that these demands about what this formal postponement application needs to entail in an open session of this, rather than to have had an opportunity, even after either a stand down or a postponement was asked for today, given that the client is not here because he's presently in the hospital. So it's unfortunate we've learnt about it in this way, but my learned friend and I throughout the morning have been talking intensely about what he can give me and what he can't give me, and whether he's going to give me the CCTV footage he's already got in his possession or he doesn't. Well, I don't think we're in agreement on that, but my learned friend very kindly my learned friend has very kindly given me the license vehicle registration of the vehicles that were apparently transporting my client or not transporting my client yesterday, and we'll deal with that in due course. All I'm saying is that the manner in which we've learnt about this is regrettable, and the reason it's regrettable, and this is the second point of my fourth point overall.
How do you suggest you should have learnt about it?
That is a segue, thank you, Chair, to the second point I want to make under this, is that with all due respect, I'm now concerned that we are inadvertently using the postponement application and the allegations regarding the movements of my client or otherwise as a mechanism through the back door to undermine the otherwise unimpugned medical evidence in front of you. And Chair, you asked me how should we have learnt about it. With all due respect, I don't think it's for my client necessarily, unless you order otherwise. If you order it, well, then we have to do it. But if you don't order it, it's not for my client, with all due respect, to answer these accusations in the ether in the way that they are, where the overall purpose or effect is to create doubt about the medical excuse.
That's a different issue. You raised an issue, or rather, you complained about having lent of the information in the manner in which that happened. So I'm asking you the question, how do you suggest you ought to have gotten to know about the information? That's different to what you are saying.
Yes, Chair, thank you. The way in which we should learn about it, and I know Chair says to me it's a different issue, I will respectfully say it's not a different issue, is because if the purpose or effect of that accusation is to raise doubt about my client's medical condition and whether there's a legitimate excuse for his attendance or non-attendance at the commission, because that's what the sting of that accusation actually is, then actually the shoe should be on the other foot, in the sense that it should be the commission, the evidence leaders, bringing an application where they raise this evidence in the round of questioning the medical advice or otherwise, or the medical reports or otherwise that have been tabled in front of you that otherwise serve as the excuse. It's not the hill I'm going to die on. All I'm simply saying is that I'm concerned that the way in which these accusations now have to be dealt with is almost reversing the onus that otherwise falls on my client.
That still doesn't answer my question.
I apologize, Chair.
Yes. The question of how Mr. Carrim must respond is something other than your suggestion about, maybe the word I'm going to use will be strong or too strong, the impropriety that you suggest with regard to how you came to know is what I am addressing. That has nothing to do with how Mr. Carrim then deals with the information. So my question is, how do you suggest this information ought to have landed on your or Mr. Carrim's lap?
In writing and particularized, so that it's formally placed in front of us, rather than as what happened between my learned friend and I, which was a conversation between colleagues regarding these issues that are now being raised. So that's when I talk, and Chair, with all due respect, impropriety is a far higher word
That's exactly
Yes.
why I
Yes.
said maybe it's too strong a word.
Yes,
Yeah.
because I'm not,
But,
I'm not accusing my learned friend or anybody of impropriety. I'm just raising my concern about the manner, and then that's the direct answer.
Maybe instead of impropriety, I should have said concern,
Yes.
which is the word you've just used now.
Yes. So Chair, I think we're ad idem then that it's concern, not impropriety, and formally in writing, because these are very serious accusations, and I understand that my learned friend is under his collegial obligation to give me notice that he was going to raise it today at the hearing, but he could have perhaps, we could have reached some or other arrangement about being informed about this formally and then given an opportunity to respond. But we are where we are now, so that's water under the bridge, I suppose.
Yeah, I was going to say, why is it that the informal advice cannot serve the same purpose as written advice?
Well, I suppose because my learned friend is not the witness. So when my learned friend, and neither am I. So when my learned friend says to me, you know, these are the core of the allegations, it might turn out that some or other detail about that is going to change or not change, and there should never be a dispute between my learned friend and I as to what he said to me or what he didn't say to me. I mean, if my complaint is at this point only boiling down to housekeeping about the form of communicating the information, I accept that that might not be an issue which needs to detain the Commission.
The issue, as I understand it, is not so much about the interaction between the two of you. It's about Mr. Carrim addressing what we are told has since been discovered.
Yes.
So the focus is less about the interaction between the two of you.
Exactly.
And the point being, if indeed it is true that Mr. Carrim was at some food outlet out of town, I think reference was made to his vehicle or vehicles, I'm not sure now whether one or two or more. So point is, when you apply for the postponement, why is it, or rather when he, Mr. Carrim, applies for the postponement, why is it that he should not, in the application for a postponement, deal with those? If he says, I was never out of town, I was never at this alleged food outlet, and therefore, my medical certificate stands, and it is to this effect. Nothing has changed. I do not see what the hurdle is, Mr. Carrim, dealing with the new information on that basis.
Agreed, but I think that's also I'm sorry, Chair.
Yes.
May I respond?
Yes, please.
Thank you,
Yes.
Chair. But that's the point, with all due respect, is that, remember, when we arrived here in front of you today, it was on the basis of what was known before my learned friend disclosed the new information.
Yes.
But now what's happening is new information is being introduced, which may need to be dealt with to justify future postponement, but the basis upon which we're here in front of you today is the different historical facts, not the new facts introduced now.
That's exactly why Mr. Carrim is being afforded an opportunity. And it's not as if Mr. Shaskalson is saying and we want Mr. Carrim to deal with this now, and that's it. Mr. Shaskalsin is suggesting to the commission that Mr. Carrim must be afforded an opportunity to file an application / affidavit dealing with these developments. So, in the light of that, I would suggest to you, subject to what you say, in the light of that, it should not matter much what you originally came here for today. Things have changed, and because things have changed, Mr. Carrim is being afforded an opportunity. So unless other submissions are made, I do not see what the unfairness to him would be. Mr. Carrim, because of these developments, bring an application which will be heard on Friday at whatever time. It could even be in the afternoon, and deal with these developments. Tell us why you are not able, for example, to provide the commission with the information it required, or to give the necessary instructions to whoever may do so, to give the commission that information. So in that application, he must deal with all of that.
That's why.
And issue, as I understood Mr. Shaskalsin being, this information was requested a long time ago, and Mr. Carrim has not provided it on the basis that he is not well. Now, these developments referred to by Mr. Shaskalsin, at face value, suggest that Mr. Carrim is going on about his life. That raises the question, if that be so, and underline if that be so, how can it be that he is not able, either himself to furnish that information or to do so through others? And he's afforded an opportunity to respond and say, I cannot, I simply cannot. And to do that, and to move the application on Friday. I'm not saying that's what we are going to rule, but that is what Mr. Shaskalsin is submitting should happen.
Yes, Chair, and I accept that. That's why,
Yes.
that's why I placed manner and form no higher than a concern, rather than using that favorite A word of ambush, and also claiming trial prejudice and fair trial rights. I was, with all due respect, simply placing on the record a more subtle concern from my client. That's all. And that's why I've resisted putting it higher than that. May I just say that in respect of the face value concern and the timing of the evidence and the way Chair posits to me what Mr. Chaskelson put to you, Chair, you've already heard me on that page 128 paragraph of the bundle as the explanation. But insofar as and this is now...
Please take me to the relevant lines of the first paragraph. The first substantive paragraph, not the intro.
Yes,
Yeah,
the first substantive paragraph is about whereabouts. So that's inability to attend, to use my learned friend's phrase.
In respect of the second paragraph,
Yes,
you referred us to specific
the explanation,
lines.
yes.
Specific lines.
If you look at the second sentence beginning on line 2...
Starting after. We're not going to read it.
No, we're not going to read it, indeed
But
not.
is that the one starting after?
No, given.
Oh, given.
On my side, I have given.
Okay. All right.
I'm indebted to Commissioners Baloy and Kumalo.
I thought you referred to the first paragraph as well.
Yes, I...
So I had no problem at all with the second or the last paragraph.
Yes.
So what I was raising with you was, please direct me to something on the first paragraph. So are you saying you said nothing about the first paragraph?
The Chair, just to be clear...
The first paragraph starting Mr. Carrim.
Well, the problem is they both start Mr. Carrim.
Oh, let me look. Has been. The big
yes,
paragraph.
Okay. So
Mr. Carrim has
the
been.
bean paragraph,
Yes,
if we can call it that.
Yeah, do you have lines you want to refer to?
No.
There?
In the bean paragraph is the whereabouts explanation.
Okay,
And if I have to point you to particular lines, I would say from the date mentioned in
okay.
3, running on to 4, as it continues. And then there's an
Okay.
explanation there which I don't need to go into.
Okay, okay.
And then in the second paragraph,
Yes.
the remains paragraph, not the been paragraph. In that paragraph, I would ask you to look at the second line, the second sentence starting given. And I would say that that second sentence, which runs on to line 4, ending before the word his, is the critical one regarding inability to explain. The third sentence, which starts his present, that also adds color, but the critical one is the sentence I've highlighted. So that's the face value explanation. That's the response to Chair's point about face value and explanation. But Chair, can I, on my fifth point, I said to you 5 points briefly. It's not that brief, but fifth point briefly, is the timetable. I've heard my learned friend where he's given 2 options for the timetable. He says 10 o'clock tomorrow, reply by 6 o'clock, Friday 9:30 for argument. Alternatively, if I'm not mistaken, he said 1700 hours tomorrow, 1000 hours, they'll respond the next day on the Friday, I think, and then we'll argue on the Friday afternoon. Can I just make 2 points about that? Obviously, the first one is obviously we're in your hands regarding your directive and the timetable for the hearing of that application. Before we entered the room, I did specifically ask my learned friend if he would consider our ability to have that argument next Friday, because you will know that in the correspondence there's consistently been the issue raised about our ability to take instructions directly from Mr. Carrim and having to rely on the medical practitioner and the family. And so there might be practically some delays in obtaining the level of specific instructions that we have to now obtain. But as I say, I'm in your hands on that. You will direct as you need to direct. The second point, and I think my learned friend and I have reached an in-principle agreement on this, but if I'm wrong, no doubt he'll correct me in reply, is that Friday, insofar as, I'm just using Friday as the placeholder date, Friday, insofar as we end up needing to discuss medical conditions, hospitalization dates, even identity of the medical practitioner and the speciality that they may or may not specialize in, obviously impinges potentially on my client's medical privacy rights, and also around causing unnecessary public, in an open sense, public speculation about his state of being or not being. And I've already flagged with my learned friend that we might need to be because for the exact reason that I can't read to you what the contents of the medical report actually says, I have to use all these sideways descriptions of directing your attention to content. It might be appropriate for us to have that debate at least in camera without the journalists and the outside world reading in, to the extent that we need to go into that medical history and the details. So never mind the timetable issue, Chair. I think in addition to, if you direct that we have to bring the formal postponement application in the way that it's posited, I'm giving advance notice to you as the Chair and the Commissioners, and I've flagged it and I've discussed it with my learned friend, and he was very understanding, I'm grateful, that we might need to then have that as an in-camera session so that my client's medical privacy rights are protected and his dignity is not unduly impaired as a result of what information we, as the Commissioners, the evidence leaders and his legal representatives, need to have a frank debate about in a way that still manages to protect him. So, Chair, those are, may I just check with Ms. Madlanga, who usually holds the purse strings?
Yes.
Ms. Madlanga says I've done my job, so it's fine. Thank you, Chair.
Thank you. Mr. Shaskalsin, any reply?
A brief reply, Chair. First, in relation to the businesses, why I mention the businesses is not to say that these are unlawful earnings or that these earnings are, proceeds of crime or anything like that. It's to say there is a very substantial business group that is carrying on in the apparent absence of Mr. Carrim. And if the group can carry on in the apparent absence of Mr. Carrim, then it's not clear to us why we can't get, through a simple request from Mr. Carrim, details like financial statements of 3 of those companies in the group, the identity of the auditor of 3 of those companies who we still haven't been able to ascertain from repeated requests to Mr. Carrim. So if he can keep his businesses ticking over remotely from his sickbed, he can also issue an instruction that the information that exists external to him can be made available to us. And he hasn't done that for months now. The second issue in relation to the medical report is it's curious to hear my learned friends saying we haven't impugned the validity of the medical report, because last time we were here, you'll recall that there was a suggestion on the table that Mr. Carrim should make himself available for independent medical examination, and we were told, oh no, you don't have the powers to do that. You're not a high court with powers under the rules, you can't do that. He won't make himself available without you, and you don't have the power to do that. So now we're told you can't examine him, you can't get an independent medical report, but when you have extrinsic facts which give reason to doubt that he is unable either to appear or to furnish information that you've asked, you cannot raise them because you're not impugning the medical report. Well, they can't have it both ways. If Mr. Carrim wants to make himself available for our own independent psychiatric or other medical examination, we will do that. We will do that, and we will arrange that an appropriate specialist dealing with whatever medical conditions he has raised, which range across a very wide spectrum, are investigated and a report is furnished. Finally, I want to emphasize one particular misconception, and it is this. Mr. Carrim comes here asking for a postponement without making a postponement application. We have information that makes us concerned about the bona fides of his claim to a postponement application. We are giving him advance notice so that his postponement application can address those issues on which he will have to satisfy the Commission. He seems to proceed from an assumption that he can have a postponement if he wants one, and it's for the Commission to show that he shouldn't have a postponement. It works the other way around. He needs to satisfy the Commission. And in order to satisfy the Commission, he's going to have to address these concerns that we've raised. That's why we've raised it. And that's why we've raised them informally, and that's why we've raised them in advance of a postponement application. In relation to the timetable, we have suggested Friday because we have had a succession of witnesses this week who were scheduled who have not appeared and who are not appearing. So scheduling this postponement application on Friday will no longer interfere with evidence time that we have scheduled. We've had, in fact, all 5 days of scheduled evidence, originally scheduled evidence, or 4 of the 5 days of originally scheduled evidence this week fall away because of postponement applications. So this Friday is not going to interfere with scheduled evidence time. If we get to next Friday, we will interfere with scheduled evidence time. And the debates in relation to Mr. Carrim's evidence and appearance and non-appearance have thus far taken up days of Commission hearing time, and we don't have days to waste. So we want it done this Friday because this Friday currently is a day which is sitting fallow. As far as the in-camera concerns raised by my learned friend go. If there are legitimate concerns in relation to privacy, we are happy to accommodate them, but whatever happens in that regard needs to be tailored very tightly so that any in-camera process is confined to that which is necessary to address the privacy concern. Those are our submissions, and we would ask that this postponement application be brought on a timetable where we can give the extra time to our learned friends. They can file their papers by close of business tomorrow. We will respond by 11 o'clock on Friday morning, and the postponement can be heard on Friday afternoon.
Chair, excuse me, Chair, may I seek, firstly, as a matter of protocol, may I seek an indulgence to address you on one point that I must respond to that was raised by my learned friend? It's this point about my client can't have it both ways, about the independent examination on one hand and then subpoena the doctor. You will remember in that general discussion we had the last time, it's not one or the other. My client placed on record that the power of independent examination is open to serious doubt. And you'll remember I explicitly said, I used the phrase, there are less intrusive means that are available to the Commission if there's a doubt about the medical evidence, and the subpoenaing of the doctor is one such option. So there is no inconsistency between what I have said to you today and what I have said to you previously, and that's as far as I'll take it. Thank you, Chair.
Thank you. On this, Mr. Oh, sorry.
Mr. Premier, I understood Mr. Chaskalson to simply be making the point that you are not correct to say this medical certificate has not, no doubt has been cast on it. And all he was saying was, we have said he should go for an independent examination. That's the only point I thought he was making.
Then please strike what I've just said from the record if I was incorrect in my understanding of what my learned friend said. I just wanted to make sure on the record that there's no ground to suggest an inconsistency. And that's as far as I'll take it. Through you, Chair, obviously. Thank you.
Thank you, Mr. Premier. I guess there's no need to respond, or is there, Mr. Chaskalson?
No, Chair.
Thank you. Just one aspect. I assume that the several issues you itemized are the sort of issues that would have to go to a ruling or the ruling. Or not? Remember, you itemized a few.
Yes, I've certainly itemized. I'm not suggesting they should go into an order, but if they aren't responded to if they aren't addressed in the postponement application, we will ask the Commission to draw its own inferences.
We proceed on the basis that Mr. Carrim, through his legal representatives, has heard the issues that you itemized.
Just in fairness to Mr. Karim's legal representatives, maybe I should run through them again. And what we were asking for was the dates on which Mr. Karim has been admitted to hospital over the last 4 months.
Just, I see the paper is being sorted out, and I think when you started, they were not ready yet. Please, Mr. Chaskalson. Yeah.
The dates on which Mr. Karim has been admitted to hospital over the last 4 months, the dates on which Mr. Karim has attended medical consultations over the last 4 months, his travel movements over that period, how he traveled to Cape Town in the last week, if indeed he or beforehand, if indeed he has traveled to Cape Town. And it seems that he has traveled to Cape Town because one of the medical reports speaks to hospitalization in Cape Town. Whether Mr. Karim has attended social engagements over the last 4 months, whether he has played a role in the management of his business over the last 4 months, and if not, who has been responsible for the management of his businesses.
And Chair, as a clarity, I think Mr. Chaskalson's extension of the travel arrangements covers Commissioner Kumalo's supplementation of the original list, so to speak.
And let me just clarify where it comes from. In his presentation, Mr. Chaskalson said they have information that he has been traveling from the northwest. So I know that there's no airport in the northwest, so unless he drove to Cape Town, I'm assuming he would have flown from either OR Tambo or the other airport. I can't remember what it's called for now. So that is relevant to me, because if you can give instructions to anybody to book flights for you, then you can give instructions to those who are running the business to provide the detail the commission is looking for.
Yes, thank you. Thank you, Chair and Commissioner Khumalo.
Oh, just, yeah. Perhaps, before, I'll give you a chance, Mr. President.
I was saying thank you for the clarification and the amplification as to the travel arrangements, because my learned friend said travel arrangements broadly, but Commissioner Khumalo has a specific travel arrangement in mind that needs to then be dealt with. That's what I was saying thank you for.
Thank
I'm
you.
indebted to Commissioner Baloy.
Thank you. And Mr. Chaskalson, perhaps it's best for you to just give a piece of paper to your colleagues.
I'll do that immediately after the
Thank you.
Mr. Chaskalson, you have narrowed down his activities, business activities, to management. Can I suggest that it be in the business affairs and not narrow it down to management, because management could easily be interpreted as being purely operational. And what we would like to know is what has been his involvement, if any, in the affairs of his businesses. Thank you, Chair.
I'll do so, Commissioner.
There is the matter of detail around the exact timing about filing, for example. Let's leave you and Mr. Premier to discuss that detail and even the time when the application should be heard. But let me upfront say that the decision I make is for that postponement application to be heard this coming Friday. But the question of when exactly tomorrow the application should be filed, when the answering affidavit should be filed, and the exact time at which the application should be heard on Friday, may I ask Council to please discuss that. And once you have agreed, Mr. Premier is excused, and Mr. Chaskalson can just bring that to our attention, say after lunch, and a ruling then gets made.
Thank you, Chair. We will do that.
Chair.